Some FAQs on California separation of powers doctrine. What is the separation of powers? Essentially, the powers of government are provided to separate branches of our state and federal governments for them to operate separately. These powers are set forth in the California Constitution in Article 3, Section 3, and they are granted to the legislative, executive, and judicial branches of state government. What is the practical application of the separation of powers doctrine? This doctrine essentially provides that those who exercise power in one branch of state government cannot exercise the powers of the other two branches of state government. What does Article 4, Section 1 of the California Constitution provide? The legislative power of this state is vested in the California legislature, which consists of the Senate and Assembly, but the people reserve to themselves the powers of initiative and referendum. What does Article 5, Section 1 provide? The supreme executive power of this state is vested in the governor. The governor shall see that the law is faithfully executed. What does Article 6, Section 1 provide? The judicial power of this state is vested in the Supreme Court, courts of appeal, and superior courts, all of which are courts of record. Does the separation of powers doctrine limit the branches of government? Yes, because it basically limits each branch from exercising the main functions of the other two branches of state government. This doctrine also provides a system of checks and balances so that no branch has total control over the state government. Is there overlap of some power despite the separation of powers doctrine? Yes, of course. For example, in the legislative process, we know that while the legislature writes and passes the bills, the governor can sign or veto those bills. And of course, once enacted, the courts can validate or even overturn those laws enacted by the legislative and executive branches of government.